Business organizations, fraud, corporate misrepresentation and deception. Fraud is broadly defined as intentional deception injuring another. Intentional deception has existed since the earliest times, and a number of laws have been developed over the years to restrict various forms of fraud. Fraud is a common law tort. It's a common law crime that's been codified in statutes in many states. Following the 1933 Securities Act, designed to protect investors from unscrupulous stock market fraudsters, specific U.S. federal securities law provisions were enacted, including Section 10B-5, broadly addressing all forms of fraud in the sale of securities. Section 11, addressing misstatements in the registration statement filed when the shares are registered with the SEC. And Section 12A2, specifically addressing fraud in the prospectus. Section 10B-5 prohibits any act or omission resulting in fraud or deceit in connection with the purchase or sale of stocks, shares, bonds, or any form of security. Unlike Section 11 and 12, that are narrowly focused on certain types of fraud, Section 10B-5 is very broad in scope, reaching a wide range of defendants and a wide range of misstatements or omissions. Common law tort fraud claims would be brought in state court, but in securities cases federal jurisdiction is usually triggered when the defendant uses any means of interstate commerce, such as postal services, telephone, etc. The logic goes that misstatements reduce the value of the company's shares, and a 10B-5 suit enables the resulting losses to be recovered. Officers, directors, securities brokers, and other defendants can all be held jointly and severally liable. So the court can force one defendant to pay all the damages, then recover contributions from the other defendants. A 10B-5 case can be brought by a shareholder, a private party, as well as the federal government via its agency, the SEC. The shareholder must have actually bought or sold shares for standing to bring suit. The plaintiff must show 4 factors. The claim is triggered by a false statement or omission of a material fact. Anything that would affect a reasonable investor's decision to buy or sell shares is considered material. Then the shareholder must show scienter, intent to deceive, manipulate, or defraud. Negligence is an insufficient basis. Scienter can sometimes be difficult to prove, but is necessary in a 10B-5 case. Reliance is a required element, but it can now be assumed, as the misstatement is assumed to have affected the market share price. In a common law fraud case, brought in state court, the plaintiff must show he relied on the fraud. But reliance can be presumed in a 10B-5 case involving publicly traded shares. The 4th element of a 10B-5 case is causation of damages. The plaintiff must show that the misstatement proximately caused damages to the share price. If the shareholder can show these elements, she has the basis of a 10B-5 claim. This is true in small, privately held companies, as well as large, publicly traded corporations. The large number of class action 10B-5 suits placed a large burden on the courts, corporations, their officers and directors. Corporate officers were unable to make statements about the future of the company without fear of substantial liability. In response, the Private Securities Litigation Reform Act of 1995 was designed to reduce the number of frivolous securities lawsuits filed in federal courts, and created a safe harbor for certain forward-looking statements. Statements identified as forward-looking and accompanied by cautionary risk warnings could be exempt from 10B-5 liability. This is why you see forward-looking statement language in corporate press releases, SEC filings, and other public statements. Another key provision of the 1995 Act forced plaintiffs to plead scienter-related facts with particularity. This means they must show specific facts indicating the defendants had intent to deceive. The liability of defendants not engaged in intentional fraud was limited to their proportionate share of the harm caused. This protected large securities brokerage firms and defendants with deep pockets, picking up the tab for all the losses incurred by the plaintiff shareholders. The 1995 Act also addressed some procedural and class action issues in relation to 10B-5 and other forms of securities litigation.